Good morning, welcome back. This is our second segment exploring shareholders. In our previous segment, we explained what a shareholder was, what it meant to be a shareholder as an owner, and we talked about the rights and powers of shareholders, including the right to appoint or in some cases remove directors, the right to vote on shares, the right to have a proxy vote for you if you choose, or to solicit the proxies of others, so on and so forth. In this segment, we're going to explore the right to vote in a little bit more detail and talk about how the interlocking relationship between shareholders is important to keep in mind when one is a shareholder. And even the right to vote on important matters may have important limitations that one should anticipate in advance. And to illustrate this, we're going to talk about a case called Case versus Sink and Rise Incorporated. And this is a lawsuit by Shirley Case against the husband that she owned. The husband with which she owned a company called Sink and Rise Incorporated, which was a Wyoming corporation. And this appears as the second case versus Sink and Rise, in the chapter regarding corporate directors, officers, and shareholders. So the issue that came up was that there was a shareholder meeting, and only the husband, who was John Caleb Case, he was the only shareholder present at the meeting. He concluded that a quorum existed, and he voted and passed several important resolutions, including replacing his estranged wife, who was Shirley Case again, and as the corporation secretary. All right, Shirley filed a complaint to set aside the corporate action that occurred at the shareholder meeting on a couple of bases, including the fact that she owns shares that she should have been able to vote. The trial court held that jointly held stock that are held by husband and wife could be counted for the purposes of a quorum in the absence of either personal attendance or a proxy from both owners. And the resolutions were passed with requisite authority. The resolutions removing her as the secretary of the company were proper. And again, on appeal, this was affirmed. It was held that the district court was correct in holding that the shares of stock co-owned by appellee and appellant, that's the labels for the parties who are appealing, were, quote, entitled to vote pursuant to the bylaws of the corporation. The court was correct in its characterization of their stock holding as being tenants by the entirety because of the stock's representation in person at the shareholder meeting. The stock could be counted for quorum purposes, and consequently, the resolutions were passed with requisite authority. So, in this case, the husband essentially shuts out his wife, and she is co-equal. They own all of the shares as tenants in the entirety. And so, tenancy by the entirety, we haven't had an opportunity to talk about that, but it's basically a type of concurrent estate, generally in real property or other types of property, as here, and it occurs when the people are married. Each spouse has an equal and undivided interest in the entire property. So essentially, both spouses mutually own the entire thing, and either one of them can do whatever they choose with it. And so the consequence of this feature of tenancy by the entirety gives Mr. Case the right to dispose of at least the votes for the shares equally with his wife. They both own the entire thing. And this meant that he was able to call a quorum for a meeting at which he was the only shareholder present. And though it sounds shady, it's perfectly legal because of how they held those shares, right? She didn't hold her shares separately. They could have had some other type of arrangement, right? She could have claimed the right to vote. They could have, by agreement, agreed that they each had the right to actually vote 50% of the shares, 100% of which they held in the entirety. So the quorum issue, right? So the court looks to see if the calling of the quorum is proper. And a quorum is basically a minimum number of voters as set generally by state statute that must be present in order to constitute valid action pursuant to a shareholder vote. And generally, in most company bylaws, because this can be determined by bylaws, set this number at 50%. The 50% number is pretty standard, but there are states that permit articles of incorporation to set a higher or a lower quorum requirement, right? But in this case, Mr. Case was able to determine that a quorum existed. If a quorum existed, despite the fact that he's the only shareholder present, right, then his action was appropriate. And in the context of this being with regard to his estranged wife, that doesn't mean that she doesn't have any rights. She's still a shareholder. What was the consequence? He removed her as an officer. A secretary is one of the traditional offices of a corporation, and a small privately held corporation especially. So by removing her from the operations of the company, he doesn't remove her ownership, but he does take away a lot of her power, because shareholders alone, right, are sort of separated from the management of the company unless they also happen to be managers, right? So in the course of them being estranged, if assuming that this results in a divorce, she is, in a sense, she's in a newly subordinated position and loses a bit of power. Some of this will theoretically, she'll have other opportunities to protect her rights in the property in family court if it turns into a divorce, right? But with regard to the propriety of Mr. Case's corporate action regarding sink and rise and taking control, he was unfortunately fully authorized to do so by the way that they held the shares and by the bylaws that they established between them, right? The articles set the articles of incorporation would set the quorum, right? The bylaws might detail voting requirements, right? And indeed, in a marital situation or in any closely held company, it is probably pretty wise to have a shareholder agreement because this, if it were not sort of legal, would look a lot like shareholder oppression. That's why I say unfortunately. If there were marital issues to be worked out, right? Legal issues relating to the marriage to be worked out, including holding this property in common as tenants in the entirety. I'd prefer to see that worked out in a separation agreement or a family court sort of scenario. But here it was definitely, certainly if I were in the position of Mr. Case's attorney, If he did this according to what his attorney told him to do, then he was given very good advice. So your challenge in relation to this segment is this. Take a look at the case again, case versus Sink and Rise, with its rationale in which the Supreme Court of Wyoming affirmed the lower court's judgment, holding that the shares co-owned by the cases were entitled to vote. And because they were represented at that meeting, he was proper in declaring a quorum and taking corporate action, removing Mrs. Case. All right, so review Case versus Sink and Rise, and then go back in time to a period when before the estrangement. What provision should have appeared in a shareholder agreement or in bylaws that might have protected Miss Case if we were advising her, right? Just draft up a contractual provision, right? Perhaps for a shareholder agreement or perhaps for the bylaws. And let me know what you think that might have looked like, or how might you have advised her to structure her voting rights, or to structure even between both parties to prevent either party from doing something like that. All right. Talk to you soon and see you in the next segment.